The Supreme Court decision in the case of PEQUERO versus People of the Philippines. There are two ways of committing the crime of usurpation of authority or official functions under Article 177 of the Revised Penal Code. First, by knowingly and falsely representing himself to be an officer, agent or representative of any department or agency of the Philippine government or of any foreign government, or second, under pretense of official position, shall perform any act pertaining to any person in authority or public officer of the Philippine government or any foreign government, or any agency thereof, without being lawfully entitled to do so. The former constitutes the crime of usurpation of authority, while the latter act constitutes the crime of usurpation of official functions. In the present case, the Municipal Trial Court found Pedro guilty beyond reasonable doubt of usurpation of authority or official functions. The Municipal Trial Court did not, however, clarify whether he committed the crime by means of either the first way or the second way. Nonetheless, the Municipal Trial Court, in arriving at such conclusion, ratiocinated that per Article 152 of the Revised Penal Code, lawyers are deemed persons in authority, and by representing himself as a lawyer, he usurped the official functions of a person in authority. It may be deduced, therefore, that Pedro was found guilty of usurpation of official functions. To reiterate, the second manner of committing a crime under Article 177 of the Revised Penal Code is when under pretense of official function, one performs any act pertaining to any person in authority without being lawfully entitled to do so. The Regional Trial Court, and, thereafter, the Court of Appeals affirmed the findings of the Municipal Trial Court. To be convicted of the crime of usurpation of official functions, the following elements must concur. 1. The offender may be a private person or public officer. 2. The offender performs any act pertaining to any person in authority or public officer of the Philippine government, any of its agencies, or of a foreign government. 3. The offender performs the act under pretense of official function. 4. The offender performs the act without being legally entitled to do so. In this case, the second element is wanting. Contrary to the findings of the Municipal Trial Court, as affirmed by the Regional Trial Court in the Court of Appeals, a lawyer is not deemed a person in authority for purposes of Article 177 of the Revised Penal Code, the provision the Municipal Trial Court applied in the case at bar. Who are deemed persons in authority? Article 152 of the Revised Penal Code is clear on this point. Thus, Article 152 of the Revised Penal Code defines persons in authority and agents of persons in authority. It provides that in applying the provisions of the preceding and other articles of the Revised Penal Code, any person directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, board or commission, shall be deemed a person in authority. A barrio captain and a barangay chairman shall also be deemed a person in authority. Any person who, by direct provision of law or by election or by appointment by competent authority, is charged with the maintenance of public order and the protection and security of life and property, such as barrio councilman, barrio policeman, and barangay leader, and any person who comes to the aid of persons in authority, shall be deemed an agent of a person in authority. In applying the provisions of Articles 148 and 151 of the Revised Code, teachers, professors, and persons charged with the supervision of public or duly recognized private schools, colleges and universities, and lawyers in the actual performance of their professional duties or on the occasion of such performance shall be deemed persons in authority. As aptly stated in the third paragraph of this provision, while lawyers are deemed to be persons in authority, they are so only for purposes of Article 148 or direct assault upon a person in authority, and Article 151 or resistance and disobedience to a person in authority or the agents of such person. In marked contrast, the first paragraph of above-quoted provision does not identify specific articles of the Revised Penal Code for the application of which any person directly vested with jurisdiction, etc., is deemed a person in authority. Thus, it is this specific paragraph that applies to Article 177 of the Revised Penal Code. Under this paragraph, a lawyer is not deemed a person in authority. Obviously, lawyers are not directly vested with jurisdiction either individually or as members of some court or public corporation. Lawyers are likewise not agents of a person in authority as defined in the second paragraph of the above quoted provision, as they are not charged with the task of executing the orders of any such person. While a lawyer is an officer of the court and is an agency to advance the ends of justice, it is not considered a person in authority under the first paragraph of Article 152 of the Revised Penal Code. Since a penal statute is not to be given a longer reach and broader scope than is called for by the ordinary meaning of the ordinary words used by such statute, to the disadvantage of an accused, the court holds and so rules that a lawyer may not be regarded as a public authority or a person in authority within the meaning of Article 177 of the Revised Penal Code, the provision which Pedro stands charged for. From the foregoing ratiocination, the court acquits Pedro of the crime of usurpation of official functions. While he represented himself as a lawyer and acted as one, a lawyer is not deemed a person in authority within the meaning of Article 177 of the Revised Penal Code, in relation to Article 152, also of the Revised Penal Code. All told, the court finds it necessary to modify the joint decision of the Municipal Trial Court, as affirmed in toto by the Regional Trial Court and the Court of Appeals. The court affirms Pedro's conviction of the crimes of use of illegal alias and use of fictitious name. The court, however, modifies the penalty imposed in criminal case number 11-253, where Pedro was convicted of the crime of use of fictitious name. Moreover, the court acquits Pedro of the crime of usurpation of official functions.